Again.
where you made it. So yeah, that's good. Hi everybody, Wayne Hoffman, host of the Hoff Time Report, and our special guest today is Art Macomber. Welcome. By the way, um, no one pronounces your name correctly either.
No, it's actually Macomber with a hard B on it.
Oh,
But
well, I got it wrong too. And here I thought I was clever,
yeah.
but I go to all these different events that you happen to be at, and it's Art
Oh, there's
Macomber
6
and
different ways of
yeah.
saying it.
So
Yeah.
so with the hard B, I didn't even realize that. I've been saying it wrong too, and here I thought I was clever.
It's all right. It doesn't really matter. If you can say art, then you'll probably get my attention because there's so few arts.
There's
Really
very
doesn't
few.
matter.
There's very few.
Yeah.
But anyway, welcome to the program. Running for Attorney General as a Republican, and a lot of things to talk about. 3 candidates running, and we've invited the other 2 as well to come in. The incumbent, who is Lawrence Wasden, and then former Congressman Raul Labrador. What sets you apart from those candidates?
Well, I think the main thing is you have 2 insider candidates, and then you have me, the outsider. And I'm definitely the outsider. I've never been in government service. I didn't even go into law until I was 45. So,
How long ago was that? 2 years ago?
oh
Just
gosh.
kidding.
Well, yeah,
I don't know how old you are.
If I could look at my watch and tell, I would have a very nice watch. No, so I think that's really the primary thing. I think I'm really the only candidate who's not beholden to special interests, who's still qualified to fight for Idahoans as the Attorney General.
You said you got into law when you were 45. What were you doing before that?
Oh gosh, a number of things. I had a 25-year career with various companies, all private sector, large and small. Sometimes leading teams in the companies, and sometimes just out on my own. When you're a realtor, you're out on your own. When you're at Micron, I was the head of a product development team at Micron Computer over in Nampa, and then I was in charge of how do I phrase this? I guess sales efforts for installation and maintenance people at the telephone company, where there was. I was in the division office, and then there was 5 districts below us, and then there was 5,000 people in the field. So I'm no stranger to larger organizations, although the AG's office isn't that large. I think they have 226 people for the fiscal year. So
just to kind of get your background out of the way a little bit, what made you say one day, well, I think I'm going to go be a lawyer?
Well, I was working at Micron, and I was the head of the one of the server lines, the quad processor servers. We turned out the first little 1-inch blade server in the industry, the NetFrame 4400, which I am very proud. But I didn't have an engineering degree. I didn't get my college degree till 1998. So when I saw the .com crash on the horizon, I said, well, okay, I have to leave this industry because this industry is going to have a major shakeout. And that's when I decided to go to law school.
Was there something in particular you were looking to work on as a lawyer? Particular field? What was the drive? I'm going to go be a lawyer in private practice because I want to work on X.
No, there have been. I'm one of those people who consistently reads just all the time as a matter of course. I've always been a reader. And I have very good comprehension and a high reading speed according to some measurements. And so in every industry I've been in, I've always read a lot, and it hasn't been difficult to more or less master the industry for me. And I've always looked at law though, Wayne, and I've always said, boy, that is just a thicket. It's just a thicket. If you're not a lawyer and you don't understand the hierarchies of the law and all this kind of stuff, the history of it, how you actually make judgments when you get to a crossroads and things, you don't really see how complex it really is. But I wanted to resolve that. I didn't like that. I don't like to look at a piece of the world and say, okay, that is unknowable. I'll just never make it. And it turns out I've been reading, the U.S. Constitution and Takings Law by Richard Epstein and, justice stories, commentaries on the Constitution, just kind of in my spare time for 20 or 30 years. And so when it came time for a new field, it was really recommended to me that because I had this avocation of legal reading, I should just follow it up and just go to law school. So that's what I did.
Is there a Supreme Court justice or an attorney general that you look at and think this is my this is my style. This is the jurisprudence that I like to practice.
It's a very good question. When I was in law school in my property class, it was a very liberal law school. It was University of California, Hastings, right in the heart of the Tenderloin in San Francisco. My property teacher always used to say, if you really want to know what's going on in U.S. Supreme Court jurisprudence and get a good historical background of what you're reading, read Justice Thomas's opinions. And Justice Thomas has a particular form of originalism that I really adhere to. Although I took my separation of powers course from Justice Scalia in 2011, and there were 70 of us there, and it was a 3-day course, and there was homework like an inch and a half. Read this before you get here. It was a little scary, when you're in the room being schooled by Justice Scalia, but it turns out he's a really nice guy, and he loved all my old opera stories because I was a stage carpenter in opera, and so I had all kinds of backstage stories for him that he just loved. But I think it's that originalism that says the way that we interpret constitutions is that we look at the public meaning of the words that we're reading at the time that constitution was passed, or at the time the amendment was passed.
So there are two competing questions that I want to get to, and I'm going to try to get to them both. But so if you look at, for example, the state Supreme Court,
Mm-hmm.
does the state Supreme Court honor the original intent of the state constitution? Do you believe that their legal interpretations in recent years have been consistent with what the Constitution has to say in the state of Idaho?
It's almost difficult to say. I do know that there is the standard methodology for reading the Idaho Constitution by the court is to just read the plain language unless there are ambiguities. But the very nature of a constitution is that it's a somewhat it's as an organic document. It's somewhat there's a lot of play in the joints. Let's put it that way.
Well, I mean, for example, the Supreme Court a few months ago heard a case on a bill to restrict or the number of signatures gathered for an initiative. And in the course of interpreting the Constitution, the Supreme Court said you cannot interfere with the constitutional right to initiative. And even though the Constitution says the legislature can set the boundaries for what that entails, they just said, "Nah, that part doesn't mean anything." And there's been a number of cases like that. The redistricting case from
Mm-hmm.
a couple of months ago was the same thing. They reinterpreted two previous cases in order to reach the conclusion. So I was wondering if you ever looked at the Supreme Court and thought to yourself, "Oh my gosh, there's something not right here." Maybe you look at it and think it's okay.
Well, part of the problem, Wayne, is that there's a doctrine that the state uses as well as the federal Supreme Court. And it says we won't answer a constitutional question unless we have to. So there are a lot of questions they get. For example, I had a question before the state Supreme Court in a current case where the hearing has yet to be held, where a district court judge actually delegated his judicial power to a private arbitrator. And I questioned that. I said, I don't think that a district court judge, just in terms of, subpoenaing third parties and having people join or intervene or not join and intervene, this type of thing, I've never seen a private arbitrator get those powers. So I asked the state Supreme Court, and it turns out, for various reasons, they just didn't want to take up that question. They didn't want to talk about it. It is frustrating, though, because many times it seems like the Idaho State Supreme Court will take a question in a direction where they either defer to the executive branch, which they do on both rules and statutory interpretation, or like you say, they'll just take this snippet, but they'll disregard the rest. And in the redistricting case recently, I was flummoxed, and attorneys throughout the state have no idea what to do with this case. This is the one that Brandon Durst bought or brought to the court. And they didn't overrule these cases. What was the word they used? It was like or it was like they waived them, or they disclaimed them.
Pretty much. I think that's a
but-
disclaim is probably a good word.
The problem is that no lawyer knows what to do with that. You get a case that's been disclaimed. Now, how do I argue that? Now, we all know that if the case is not published in the Idaho reports, that you can't use it in argument. You can't cite to the case if it's not published. You can use the arguments inside as your own. I mean, you could read it and you could take those arguments and go, okay, I like the argument, I'll use it myself. But you can't cite to the case if it's not published. So that's a bright line that we have. But this idea, and then of course, if you overrule a case, if you say that case is not good law, we're overruling it. So that clearly takes it out. And you wouldn't want to cite to it again unless you had argument from it that was useful to you. But you normally would not cite to an overturned case unless it really helped your case that was overturned. But this whole idea of disclaiming prior cases, nobody knows what to do with that. And I asked, I think, Attorney Brian Smith brought the case as counsel of record for Brandon Durst. And I said to him, you should appeal this. You should at least get a motion for reconsideration or for rehearing before the court to help all of us thousands of attorneys throughout the state figure out what this means, because we don't know what to do with this.
Well, Ada County they filed a motion to reconsider and was summarily rejected, slammed down really by the Supreme Court. And the Supreme Court actually altered the previous opinion that they had issued, which was fascinating to me. And all this brings me, the reason I'm bringing
I didn't know that. So what did it come out to? Did they get rid of the word disclaim?
No, they changed some of the what I don't remember the exact details, but they changed some of the details in the original opinion that the Ada County had objected to. And it was really a stunning thing. I haven't had a chance to really write about, so I don't know if anyone really is aware of it, except for maybe the folks in Ada County who, they've got a problem. I believe they're going to try to appeal this U.S. Supreme Court. But the reason that the Supreme Court question is interesting, I had heard, and I don't know if it's true, I want to ask you, that some people were trying to encourage you to run for the Supreme Court this time out. And this, obviously, if true, then I presume you said no. But what's the reason? Is that true? And why did you say no?
Well, it all goes back to my law school training. The school was so liberal, Wayne, that I had to join the Federalist Society just to get some intellectual counterweight on the other side. And that is precisely how I've used my involvement with the Federalist Society is to expose myself to the top conservative legal minds in the country. Robert Bork, I've had an extended conversation with him before he passed away, Justice Scalia, various circuit judges. I don't name drop, but these people really challenge your mind. And that's really what, if you go to school late, you really want the challenge to your mind. You really want to follow up and do it right. So very early on up in Coeur d'Alene in the first district, I was asked to be a judge. In fact, twice I was asked to be a judge. And as you know, the Federalist Society has specialized in placing judges. What some people don't know is the law school I went to, University of California, Hastings, places about 40% of all the judges in the state of California come out of that school. And so the particular way the law school approaches the law and the way that the Federalist Society has helped me hone my intellectual skills, I became noticed in the first district. And so they said very early on, Art, would you like to be a judge? Well, the first time I was asked, I was only in law for 5 years up in Coeur d'Alene. The second time I was asked, I thought, well, I better take this seriously because now I have two separate first district judges asking me. And I really had to look at myself and say, well, what kind of a person is a judge? And luckily, because of those experiences, I knew. And in fact, I talked to a judge in the second district. I went to interview with him to ask him about being a judge. But, I kind of had this sense that I knew I was not a judge, because if you think about what a judge really does, they really sit there and wait for cases to be brought to them, to their inbox, and then they assess the facts, and then the lawyers come and argue to them what law should apply and how it should apply, and they make their case, and then the judge makes the final decision, or the judge works with the jury to make a decision. And so in the end, it's a very passive job, and it's a very cloistered job. It's a job where you sit in your office and you don't get to have many friends because there may be a conflict of interest. And so if you're really a get up and go builder type like me, it just doesn't fit very well. I'm way too outspoken. I like to get up early and stay late and bring a lunch and work hard all day long. Not saying the judges don't work hard, but they don't get to initiate things in the public sphere. They have to kind of wait till it comes to them. And I've talked to several judges over the years and about this phenomenon of just, waiting until things get to you. And it would be very frustrating to me. It wouldn't work. So there's a thing called a judicial temperament, and I don't have it.
Self-realization is a pretty good quality, I would expect.
Yeah, well, it's very helpful. And if you get to be, in your 60s and you don't know which direction to go. And here's another problem I realized. There are some people, particularly some folks that asked me to run for state attorney general this last time and said, well, Raul's our fair-haired guy. You got to get out of his race. Everybody else does. You need to get out to run for this other thing. And I realized that people honestly believe that these positions are interchangeable. I'll give you an example. Like, I would never do Brandon Wolf's job. I mean, that's a numbers job all day long. And if you go to the website for the controller, it's daunting. I mean, I look at it as an attorney and I say, okay, well, let's get some numbers people in here so I can navigate the website, because I really don't want to have to do it. The Secretary of State is an interesting job, and so is state superintendent. Both of those jobs have to do with working with people far flung throughout the state. Brandon Durst has talked about, I want to have separate offices for the superintendent around the state so I can be more conversant with the local districts. I thought there was 114 school districts in Idaho. I saw 115 the other day. So I don't know if it's 14 or 15, but that's a lot.
I think it's past that now. It's in the 120s.
Is it really?
If memory serves, yeah.
So there's that, that situation with the school boards. And then the Secretary of State has to deal with the county clerks. And they're entirely different functions. The county clerk actually puts out, or the Secretary of State puts out, an elections manual and then helps the county clerks actually perform the procedural functions for elections. On the other hand, the State Board of Education says, well, here's what our targets are. And then the school boards get to lead the way. And I have some 81 videos on YouTube right now. If you just, go search YouTube and you'll find the videos, and all these 1 to 4 minute videos are videos I created to answer questions from people on the trail.
You call them the Macomber minutes.
Macomber minutes.
Right.
Yeah. I tried to keep them to a minute.
You did not really. I don't think I've
did.
ever seen one that was a minute.
I
haven't watched all of them.
I've worked very hard at it, but yeah.
But you're talking about law, and sometimes it can get complicated. And
well, the thing that I've been trying to do is, like, this week I'm addressing some of those school issues, because people don't know, especially down ballot, they don't know the Secretary of State from the AG, and what is the AG and what does that stand for? And I'm like, it's not aspiring governor. Not for me. For some people, I don't know. But the AG, they wonder, well, why do you say it's a law job and not a policy job? And what is this? So once I get 3 or 4 questions on the trail, then I make some videos because I figured, okay, there's enough people out there asking the same question. And one of my things is, because I didn't go into law till I was 45, it's really important to me that people that are not lawyers understand the law. And I think that's part of the AG's job. I don't think you can be an elected official and just ignore the people.
So this race as it has manifested, and I've seen you on the campaign trail with Raoul and Lawrence, seems to have become a race against both candidates. It's not, I mean, Raoul is concentrating almost exclusively on Lawrence's record as Attorney General. You're concentrating on the other two candidates. And what is that like? Explain how that has evolved.
Well, the reason I got into the race was because of what Mr. Wasden was not doing, in my view. And so when I take a look at what he has not done, it's really a backwards look. And I don't spend a lot of time on Lawrence Wasden because the things that he did not do, in my view, are egregious enough that everybody already knows it. And I think he's plummeting in the polls. I think he will not have any chance of
Well,
being
yeah, and I
elected.
don't know, but I want to dive into that just a little bit. So those things
Yeah.
that you believe that the Attorney General was not doing, I have heard it a billion times, but go ahead and say what you believe those are.
Well, the first one was I don't think you should be assisting your governor and secretary of state in violating Article 1, Section 4 of the U.S. Constitution by taking away from the legislature the May 2020 voting rules and just forcing it all to be mail in by the absentee ballots. I mean, when I saw the press release that said, assisted by Attorney General Wasden, I thought, how can he assist them in violating the U.S. Constitution? What is that? That just made me
Well,
crazy.
and not only that, but also rewriting the state's election laws and moving the election date,
Yeah.
which he did, just out of whole cloth, I guess.
So this just clearly is just out of bounds. And then there was millions of dollars in federal aid that came in through the CARES Act, I think primarily at first. And in the Idaho Constitution in Article 3 says that the legislature writes a bill and then it goes to the governor and it gets signed and then monies get appropriated. And Governor Little just had some group of people, I don't even know who it was, the money came in from the feds and they just distributed it however they wanted. They didn't use the legislature at all. And so I was very concerned that he didn't call the legislature back for 2 reasons, not only because of the time frame in Title 46, Section 1008 with the 30 days and then another 30 if you need it
for the emergencies
themselves, and then without enabling legislation, just sending money out throughout the state for various purposes. Those things are just so unconstitutional. And I think it was at the debate, Lawrence Wasden said, well, there's Title 67 something, and the funds weren't cognizable yet. And so we got to do with them what we wanted to. And I thought, okay, you're talking about some statutory end run around the Constitution.
It is, but
So-
it's been used for lesser things than $1 billion from the federal government coming to you in April. It's used every year for hundreds of thousands and sometimes millions of dollars. They get a grant, the legislature's not in town, and they spend the money. So statutorily, he's correct, but clearly he's not correct in the context of the state constitution.
Well, okay, so here's a copy of the state constitution. And if you read it, first of all, one thing you'll notice is the legislature is the only branch that has to take an oath to this document on this document's terms. The executive and the judicial branch by statute under Title 59 have to take an oath to support this document. But normally they don't. And the purpose is because the legislature, when it makes laws, has to see the Idaho Constitution as a limitation on its power. And so they can't make a statute with cognizable money and non-cognizable. That's
Right.
just totally unconstitutional.
Right.
And so why would they even pretend that this is not a limit on their power?
For that matter, continuously appropriated funds, so they don't have to worry about it, or automatically increasing appropriations that they don't have to vote on. Yeah, it's been a problem for many years. It's just but so you're saying that I presumably you would be the attorney general who would say, "Listen, yeah, I know that statute exists, but according to the Constitution, the legislature is supposed to appropriate that fund."
Well, if it ever came up, I would have to fight against the statute and say, look, the statute is unconstitutional.
You don't buy the attorney general's argument that his job is just to defend whatever the statutes happen to say and to justify what the governor is wanting to do.
Well, no, because he took an oath to this document. He didn't take an oath to the governor. He didn't take an oath to the legislature.
So do you file a lawsuit against the governor claiming that he's taken powers that are not constitutionally his?
Well, I would have, and I
As the
said I
Attorney
would
General.
have. Yeah, I said I would have. See, this is an area where when James Madison designed the three branches, and we're the first republic ever to have a third branch in the judiciary, he designed these branches to be adversarial in nature to each other for the express purpose of keeping them in check with each other so that they couldn't aggress together against the people. And so the design of the documents is brilliant, but who is the check if Governor Little decides to just act unconstitutionally? Now, in my view, it's not proper for AG Wasden to say, well, he's my client, I can't do anything about it. Well, that can't be right. I mean, it's not as if Governor Little is a private client now and he can just ignore his oath to the Constitution. He can just ignore the voters. He can ignore the rest of the state of Idaho and just have this little private client named Brad Little. I mean, that cannot be Idaho law, and I don't think it is Idaho law.
He also advised the governor that when the lieutenant governor is, I'm sorry, when the governor's out of state, the lieutenant governor not necessarily would be the governor.
Yeah, that was a silly opinion. It was written by one of Wasden's lieutenants, Brian Kane, who
Just saw him at the grocery store.
he argued so poorly that he wanted to put in the word effective absence from the state, as if, if I'm sitting on my boat in the Bahamas and I'm governor of Idaho, then I can just get on my cell phone and it's all good.
Yep.
But if I go scuba diving in 10 minutes, then I'm clearly absent because I can't get to my
Well, not only that, if you're out in the wilderness by Stanley, and there's no cell service, are you not the governor then? Is it based on cell coverage? Is that how this works?
Well, and that's an interesting thing. If you drive up and down Highway 95 as much as I do,
you notice you lose cell service often.
You lose cell service a lot. And frankly, I am shocked that the state of Idaho and the federal government can't get together on our primary north-south highway from Winnemucca all the way up through, Port, whatever it is up in Bonner's Ferry, that we can't have cell service. I mean, if you have an accident in Tensed, Idaho, or if you have an accident and you could just wait till the next car comes along, thank you very much. There is no cell service.
Yeah, well, I mean, probably the state and federal governments did get together, and that's why it's the way it is. I mean, I don't think you should credit the government for somehow solving that problem.
No,
They likely caused it.
I think that opinion, see, and this is the type of opinion on the absence from the state thing. This is the type of opinion that causes people to just say, well, they're just not reading the language. And the thing is, it goes deeper, because what it says is, if we can make an opinion up to justify what we want to do, then the document doesn't matter. And they're not only doing it in that one instance, what they're also arguing is that we don't have to wait for the people to update this document. This document, the Idaho Constitution, it's been updated 106 times. They've added this, they've added that. I mean, there's whole new provisions in there that were not there in 1890. And so there's a way to do it.
That's why it's this thick. And the wording is so small that I need my readers to see it.
There's a way to do it, but you do need this level of limitation on state power. The scary part is that many people don't really get a feel for, Wayne, is that the federal Constitution is a document of limited enumerated powers. And so when all the states get together, they're supposed to, help keep this beast in the cage. They haven't done a very good job in the last 70, 80 years. This document and the state constitutions generally are just limitations on state power. And so if it's not in that document, the state can do anything that the legislature may decide to do that is especially within the bounds of the police power, whatever that might be, which is usually health, safety, nuisance, and morality. That's the traditional four of the police power. And so the legislature could legislate on any topic unless this says they can't.
Yeah, which is why I'm one of the Senate candidates from up north. I said, if I'm elected, one of the things that I want to do is a constitutional amendment that actually views this document as a limitation on powers, which I find relatively intriguing. But I wondered also.
Well, it actually is. The Idaho State Supreme Court has cited to that proposition, and they see it that way. So there's actually a book that I'll forget the name of, but it talks about all the state constitutions as limitations on state power. But what it really means is that the sovereign power of the state of Idaho is actually quite strong. It is the strongest republics in the United States are the states still. And we have just become so enamored with everything being a federal question and a federal problem. And, it's just baloney.
So that's a big part of your role if
Yeah.
you're elected. And the attorney general, the current attorney general, has tended to view, in fact, on the abortion bill that recently passed the legislature is now being litigated. His argument is, well, Roe v. Wade is the law of the land, so I have no ability to do anything beyond what Roe v. Wade says. You view that differently, I suspect.
Well, I have never read anything in the federal constitution that says that the U.S. Supreme Court can expand the scope and size of the federal government simply by issuing an opinion. It just doesn't exist. Now, the U.S. Supreme Court with Roe v. Wade could have been on much stronger constitutional grounds if they had come up with, something that was beyond the emanations and the penumbras that Justice Douglas found.
Well, I mean, he basically had to take the 14th Amendment and torture it a lot and add a provision that wasn't actually explicitly in there.
Yeah. So I would say that the heartbeat case, you can't just throw it out and say it's unconstitutional. It is clearly within the traditional police power of the states. Health and safety are the first two things in the police power. It is within the state that you could have vaccine mandates if you were going to have such a thing. It is within the power of the state to prohibit abortion. It is really not the federal government's bailiwick at all. And this is where we've gotten into trouble, because remember, this one decision in 73 has us all arguing about abortion when it could have been resolved different ways in different states along the way. And then we could have learned.
Right.
This is what Justice Brandeis talked about, the laboratory of democracy, having different states having different outcomes for different policies, and then having other states learn from them. This is an incredibly important thing about our interactive republics that we've completely lost in the Roe v. Wade scenario.
You might actually get a laboratory for liberty instead of democracy, which would be even better.
You might. Yes, that's
so,
right.
I mean, looking at that then, and now you're going to get into some philosophical questions, because I've wondered if you actually had a conservative attorney general and that attorney general were asked by a lawmaker, but by the way, ignoring the problem of separation of powers there, but a lawmaker could under state law today ask that question, I guess, and maybe you'd feel honored to answer it. Should the state government take money from the federal government for programs that not are enumerated in the U.S. Constitution?
Well, no, but the first place we start is this Constitution. And if you read the 711, which is Article 7, Section 11, you might come to the conclusion that the state of Idaho cannot take any federal funds at all because we were not taxed for those funds. And in context, in not only the context of that provision, the Section 11 of Article 7, it's clearly delineating the Idaho legislature. It's not like you could say, well, the federal legislature taxed us, so it's okay to take this money, because we've been taxed for it and we're just getting it back. And you know where those arguments go. They end up going nowhere because they're making up funny money now. There is no real circumstance. We are being taxed, but that money is so far spent by the time it actually leaves.
Which would seem to violate the balanced budget provision of the state constitution as well. We're running programs on money that doesn't exist and then claiming the budget's balanced.
Right.
So as Attorney General, do you feel comfortable going to the legislature and saying, look, I know you say the budget's balanced, but 45% of your funds come from the federal government. I know that's an issue that you've talked about when you were running for the legislature before. It's an important thing. So how do you view that as an attorney general advising other elected officials on this problem?
Well, and I can't bring myself to ignore the separation of powers issues. And I have said that to the extent the attorney general's office in the executive branch advises the legislature, I want to get rid of those attorneys out of my office and help the legislature set up a legislative counsel's office. Because then you would avoid this whole heartbeat bill scenario, which has been a nightmare. If you're a legislator and you want to make a law and you go to your own legislative counsel's office, you would have attorney-client privilege there, and that opinion would not come out about your proposed bill.
Right. And also, you wouldn't necessarily be advocating on behalf of your client, the executive branch, when you're dealing with the state legislature.
Well, and this is, look at what happened with the heartbeat bill. The legislature asked A.G. Wasden's office for an opinion. He gave him the opinion. Of course, it became public because you cannot keep attorney-client privilege at that rate. Cross branches, I mean, that's just a clear conflict
The
of
legislator who
interest.
doesn't like the bill takes the opinion, puts it out there, and everybody knows.
Everybody sees it. And then Planned Parenthood sues on Senate Bill 1308, I think it was, or 1309, one of the two. And then they attach as Exhibit 6 to their petition to the court Wasden's opinion that says the bill's unconstitutional, and they argue. Even the attorney general says so you imagine you're the judge now. So here you are, the judge. And your question has to be, Mr. Wasden, you are defending the state of Idaho. You are defending this legislation, but by your own opinion in Planned Parenthood's Exhibit 6, you said this bill was unconstitutional. Now you have to argue against yourself. Please give me your argument, sir.
Yeah.
Right? I mean, it makes him.
And it happens in cases, it's happened for many, many years.
It's happened for too long. I think it's happened at least since 1997 when the legislature lost those attorneys in-house. So that's my
the attorneys were all centralized under
they were pulled in there. And I talked to Freeman Duncan, who worked with Al Lance.
Oh yeah.
And people that helped do this. Yeah. Well, he was a state senator, and he assisted. I talked to him. I said, Freeman, what about the separation of powers issue? How do you do this? How do you give an opinion across branches? And he said, Idaho was a smaller state then, and we all got along. We were all working in Boise. We didn't think it was a problem. We were being good Republicans. We were consolidating operations. We thought we were saving money, and we didn't really consider that there would be a separation of powers problem. But now, as you can see, 25 years on, the legislature is in all kinds of trouble because they don't have their own legal counsel. And the way they've chosen to address this is to give pro tem, I think it's Chuck Winder and Scott Bedke over in the House, a gargantuan bucket of money, like $4 million worth of money as a legislative attorney's fees, like a legal, so when they wanted to intervene, when the legislature wanted to intervene in the heartbeat bill case, they hired an attorney out of Nampa who I think was a former deputy attorney general. I'm not quite sure, but he's a guy in Nampa who filed the petition to intervene. And here's the thing, the state legislature was already out of session. Okay, the only people with full control over this fund are the leaders of the two houses, which is in and of itself.
They're acting on behalf of the body, and the body hasn't given them permission to do that, and we've seen that time and again.
Well, I don't know if they gave them permission or not, but I don't think they did for this case because they were already out of session when the case was filed. So that's improper also. And when, earlier last fall, when Scott Bedke said, well, I want to they were going to convene the legislature, and the question was, do we convene the legislature about the state of emergency, and maybe we can put something together? And Scott Bedke said, well, I'm going to get together with some legislators and we'll hammer out a bill, and then we'll bring the legislature back into session, and then we can vote on it. And my first thought was, wait. I looked at Article 3 and it says no secret sessions of the legislature. Well, what could be more secret than to meet with a bunch of guys, just maybe online or however you do it, and then reconvene the legislature and hold a vote?
Right.
So
it's all just it's just show, because they've already made the decision.
well, and so I called him out on that. I said, that's improper. You can't do that. Secret sessions are not allowed. 3 days later, he called up and got Sage Dixon to initiate the Federalism Interim Committee so that they could consider it in a public way. So there's, we need an attorney general who's not afraid to call out when these unconstitutional things are happening, because frankly, the only security, literally physical security and financial security, that the people of the state of Idaho have is if we adhere to these core documents. We have to follow them. The reason we follow them is because they make the government do things in certain transparent ways that we can all see, we can all track them. You don't want a government operating in secret. That is the most dangerous type of government you can have. So when you have these guys doing stuff behind the scenes and they're not following these core documents, the people of Idaho are all at risk. They're all at risk.
So there are other examples too, where, I mean, the Attorney General's office was asked to weigh in by House and Senate leadership on whether it was appropriate for the Department of Health and Welfare to have a registry, or if you will, an unofficial registry of people who have opted out of adult vaccine registration. And of course, the Attorney General's office said, well, perfectly appropriate for them to do that, even though there's no statute for that. But the deputy AG for the Health and Welfare Office works for the Attorney General. So what else would they conclude?
Yeah.
And you see that all the time, where the system is just defending itself. So do you come in as I've seen other states' Attorney General who kind of see themselves as this person that stands apart from that? Do you think that you'll be able to go in and say publicly that deputy AG working for that agency was wrong in the determination they made about whatever the issue might be?
Well, I'm really concerned with deputy AGs just stepping out there and making opinions that are attributable to the office. If there's any kind of controversy about what they're doing, I think there needs to be a review process. There has to be. I mean, in my law office, Wayne, we always had two sets of eyes on important briefs going out. You can't just depend on one attorney to go, yeah, I got this, no problem, right? It's just not functional. The law is complex enough that you want at least two sets of eyes on it. And if it goes, they probably wouldn't go directly all the way to me as Attorney General, but there's maybe the division heads can handle some of it, so that we can make sure that there's just not one opinion out there. And if the opinion, this is the problem, when the opinions go off the reservation, they have to be called out. I was asked whether I would support a situation where deputy attorney generals would be essentially sent to the hinterlands of the 20 allowed agencies so that they could just work within the agency and there would be little or no supervision. And the problem with that approach is there is an approach that the whole office needs to be on one page. You really can't advise the Idaho Department of Lands that one thing is okay if it might do something where health and welfare might get caught up in it. Well, this guy did it. How come I can't do it? You can't have those disagreements. The thing about the law that we know is that it is a body of law. And so you can't put on a sneaker on one foot and a high heel on another foot. You can't wear two different shoes. You can't wear, right? You can't treat the body of law as if it's some disparate thing. It's not. It's one law, and it's all anchored by this. And so unless we have that perspective and we start treating it that way, we will never have a stable and coherent body in Idaho.
So you support the AG's office consolidation in 1996 that put all those deputy AGs and the disparate agencies under one umbrella, the central office of the Attorney General.
I do, except for we need to have a carve out for the
For the
legislative
legislature,
branch.
okay. I just wanted to
Yeah,
be clear on
yeah.
that because I think Wasden, of course, is arguing for the status quo, and Labrador is arguing to go back to the system pre-Al Lance, if I have characterized his position correctly. So that's interesting.
You mean pre-Al Lance, where they would just be
They were all
separate?
That's what it was. So Al
Mm.
Lance, the legislature, in, I think 1995 or 96, I
Seven,
think,
yeah, I think it
97,
was. Yeah.
consolidated all of that, and of course,
Yeah.
the legislative portion got wrapped into all that as well. But there, there was a time when the deputy AGs worked basically for the agencies, and there were deputy AGs, if you will, but they were the attorneys for the agencies.
Well, and so let's broaden the scope of it a little bit. The constitutional amendment that I wrote in 2018 to allow legislative review of IDAPA rules or executive branch rules in Idaho has really been unused so far. We know the legislature gets into session and they look at some of the new rules, but they never have a chance to look at that full body of rules. And so part of my not so secret plan is to put some attorneys back in the legislative branch, have a legislative counsel's office when they're not helping legislators, either on interim committees or during the session, providing opinions, providing guidance and things like that. They could turn their big guns on the legislative, on the IDAPA rules and say, look, on behalf of the legislature, we're going to see what's going on with this body of executive branch rules. And if they did that, there are many, many rules that could be cut. And so this is one support for consolidating the agency attorneys in one office. And it works like this. If you go to the Idaho Administrative Procedures Act website and you look up every department and you click on it, and then you see the sets of rules, and building and safety has 44 sets of rules, and health and welfare is over 60 sets of rules. There's 720 plus sets of rules in Idaho for 1.8 million people. Now, consolidation of those rules could then occur because these attorneys would be viewing that whole set as a body. It wouldn't just be, well, Department of Lands has its set of rules, and see, if you put the attorneys out with the agencies, what you're going to do is you're going to create silos of agent talk. They don't have anything to do with each other. And the reason this is bad is because it hits citizens. When citizens get involved in the executive branch, that's where they get torn up and chewed up and spit out. They don't even get to the third branch anymore, because the complexity and the nature of the executive branch rules drains them of time and money. People that go into the executive branch, people that encounter Idaho government, are private people with private property and private funds to invest. And as we all know, money has to keep moving. It's one characteristic of money and business is that money has to keep moving. So if you get tied up in the executive branch for 60 days, 90 days, a year, 2 years or longer, you're going to expend all of your money and all of your time, and you may get nowhere. So what we need to do with these executive branch rules is really compress them and compact them, make them as similar as possible for all agencies. Unless an agency has a particular reason to go left or right because of a particular process that it regulates, then they should be the same. The procedural rules could easily be much the same throughout Idaho government. And this is where we need to always be cognizant of how ordinary citizens are interacting with the government. And when ordinary citizens just feel like they're bouncing their head against the wall, they don't get callbacks. They can't figure out the rules. When I was running for legislature in 2016, I was somewhat famously, perhaps the only Republican in living memory to knock on all the Republican doors in all of District 4, which is 26 precincts up in Coeur d'Alene. And at that time, I ran into an inordinate amount of working age males, fit and hale as a fiddle, ready to go. And I would ask them in the middle of the day, I said, hey, it's the middle of the day. You're not working. What's going on? Do you have a job? What's going on? A high percentage of them would say something like this. I tried to run my own business. I wanted to open a business, but I couldn't figure out how to do it. There's so many rules and there's so many permits and there's so much thing. I finally said, forget it. And I'm just sitting on the couch with the remote.
It's so much easier to go and get on food stamps.
Yeah, there's no incentive.
Yeah.
So what we need to do in Idaho with our body of law and our rules is to make it so that it's not only easy to do business in the state of Idaho, but there are incentives built in for people to get off the couch and into the workforce.
What's the AG's role in that?
Well, the AG's role is to help advise these departments that they can make it easy to do business with them. If you want to just put a dock, just hang a dock off your property, invariably some piece of the dock is going to hit below the ordinary high water mark, and you've got to get a Department of Lands permit. If you've ever tried to do that without a lot of time and a lot of money, it's tough. And some people say, well, shoreline owners, well, they're rich anyway, so who cares? That's not really the point. The point is that your government should be very responsive, very easy to do business with, and very flexible regarding situations where the rule says no, but the circumstances say, well, it doesn't matter. So why does the no have to control? So I think that the AG's office is in that position. Help the agencies make better laws. And then of course, over here in the Legislative Council's office, they can look at the full set and they could actually start to say, all these procedural rules can go. These procedural rules can be consolidated. I was at a Federalist Society annual lawyers convention 2 years ago. And I talked to a woman named Naomi Rao, who was one of the speakers, who was also the head of a federal group called OIRA, which is the Office of Interagency Regulation. And so if the Department of the Interior wants to have a new regulation, one of the things they do is send it to OIRA, and they review all the federal CFRs, the federal rules. And they say, where does this conflict? Does it conflict with anything else? And so I asked her, I said, how did you do this? How did you get, under President Trump's term, they got rid of 22 executive branch rules for every new one. And I thought, wow, that's pretty cool. I wonder if Idaho could get rid of, some of the 722 sets of rules. They got to be able to do that. And what she told me was, the first thing was, you view that as a body of rules, one body for the whole state of Idaho. You'll notice one thing, Wayne, the criminal law does not have any of those executive branch rules. There is no IDAPA for criminal law.
Right.
And so that's kind of nice. So we only have it on the civil law side. And on the civil law side, if we pay attention to how to consolidate these rules, and we can really chop them down. And so when you have lawyers in the legislature seeing if the rules comply with the laws that were passed, and then you have the AG's office advising them on how to streamline and make those rules better, then I think all of Idaho government will benefit, and we'll have the separation of powers proper, and it'll just be better.
So is it the issue of how the separation of powers have morphed into a big blob? Is it the function of the current Attorney General's office in advising the governor on various things as a client, or is it the various lawsuits that the Attorney General hasn't participated in that some believe he should have, that set you off, that said, this is why I've got to run for Attorney General? Or maybe it's something we haven't talked about yet.
Well, no, the Attorney General is the top legal officer for the state of Idaho. So first, he has to be worried about reinvigorating Idaho's sovereignty vis-a-vis the federal power, which means we have to join lawsuits where Idaho's sovereignty is threatened. And this is what Madison called for in 1832. He said, North Carolina can't just nullify a federal law, because then we'd have a patchwork quilt. They have to get together with the other states and tell the federal government that it's out of its cage, it's out of bounds. And so that's where you see all these AGs are joining lawsuits together. That is what Madison envisioned, so that we would not have individual state nullification.
But he did believe in interposition.
Well, interposition is where the freedom and liberties of the citizens are protected by both the federal and the state power. If the federal government gets out of control, the state's supposed to interposition and defend. If the state gets out of control, the federal government's supposed to step in and defend. So you had George Wallace in 1955 in Alabama saying, you can't go to that school. You're black. This is a whites only school. You can't go there. Well, the federal government brought in federal troops and said, actually, she can go to school there. So that was the federal government stepping between a state and a citizen. And so now we're looking at it the other way around. We've had a little bit too much federal intervention. Let's see the states start to get involved to push back on the federal
which
power.
is not historically unknown. The Fugitive Slave Act being a great representation of that, where the state of Wisconsin said, we're not going to return a freed slave to their southern masters, despite what the federal law happens to say and what the U.S. Supreme Court has to say about that. Yeah. Is that the place that you see yourself being in terms of the Idaho Attorney General?
Well, Idaho has a couple of major things on its plate. When you talk about pushing back against the federal power, there are individual instances like the OSHA mandates and these other mandates that come out of executive orders that are just Looney Tunes stuff. They're just outside of their bailiwick. So you got to fight those. Idaho also has 64% of its land area is frozen in federal titles, which I don't think was ever envisioned by the founders in 1787. And there's really been no amendment that would allow them to hold so much land. And if you read the federal Constitution, it says things like, well, the federal property will extend to, forts and
right. It's very explicit about the types of
property they get to hold.
Yeah. The federal government.
And so the idea that they're holding 63% of Idaho is crippling Idaho right now. And it's crippling us, the Federal Land Planning and Management Act of 1976, FLTMA, was the law that froze these federal titles. It's very, very difficult to convey land out of federal title due to that law. There's only 3 ways to do it, and they're extraordinarily limited. That was one set of videos. It was on FLTMA. But what's happened is now 76, 86, 96, 106, 116, we're almost into a 50-year period when you got to look at it from the working man's viewpoint, if you will. Regular people just getting up and going to work. Once they passed FLTMA, they closed the federal forests for all effective purposes. And in the 70s and 80s, there was nearly 70% of Department of Interior money for the U.S. Forest Service was for litigation. Okay, this is when people that were walking through the forests that came to Idaho to go hiking suddenly had standing to challenge a timber cut. In the 70s, the timber out of U.S. forests nationwide was 60 million plus board feet per year. We had no thinning problems back then. Now it's down to about 3 or 4 million board feet per year, and we're having these gargantuan forest fires. We cannot even control our own land.
So does the Attorney General, if you are the Attorney General, do you say, I'm reading the same Constitution you are, and I see no authority for you to hold this land, and so therefore we're going to go and we're going to do some emergency cutting of timber because we're afraid the forest is going to catch on fire and be several million acres?
Well, possibly. And I would probably be inclined at this point in my research to say probably. Part of the difficulty of being an attorney is you can't just pick up the nearest pitchfork and start waving it and, this is what we're going to do, because you really need to do your research.
No, but it seems based on everything else that you've said during this interview and recognizing that the state has certain police powers,
Yeah.
a bunch of forest fires, catastrophically cascading across the state, possibly killing
Certainly, no,
people.
certainly impacts our health and safety. Certainly does. And so the question is, if let's put it in private landowner use, if I'm potlatch and I own 650,000 acres in the state of Idaho, and I don't thin my land, then it becomes a hazard. Then does the state have the power to come in and cut it? It probably does.
Right.
Um, they probably have to pay for the timber they take out and probably repair the damage that they make when they go in. But it's the same with the federal government lands. If they're not managing their lands so that we're not at a health and safety risk, then I think there's a strong argument that we have to go in. But the arguments for the non-disposal policy, I mean, I think, Wayne, long story short, FLIPMA is probably illegal
But no,
because
no one has challenged the nature of the fact that you have this land and it's burning, it's potentially damaging property, possibly killing people,
yeah,
and we all just sit back and go, "Eh." But in that vein, the again, the state government receives all this federal money, and I didn't get quite through the question, but Medicaid is now the largest program in all of state government.
yeah.
And I reread my US Constitution this morning and didn't notice the words Medicaid or healthcare or anything like that in there. So perhaps you look at that and do you say, wait a minute, we're taking all this money, borrowed money from somebody else, not really a balanced budget, and you're using it for a program that shouldn't exist in federal law. We shouldn't be participating in this program. Is that something an attorney general like you does?
Well, the attorney
Or
general enforces the law as it is.
I understand
So,
that,
so
but
the question is, if we get into a battle over should we take these funds or not take these funds, and it's Medicaid, and there's nothing in the federal constitution to support it, then I think you have to take a position that we don't want to take that money. Now, do I have the power as the attorney general to say we're not taking that money? I think the governor and the legislature have more to say about whether we take it or not. But does that mean I don't point out the arguments, that I don't point out that it's unconstitutional? I mean, I think I have to, because my oath is to this, and my oath is to the federal constitution, both. So I really can't, as an attorney general and a lawyer, take a position that says, well, let's just put these documents aside because we really need the money. Okay, that's just not. You don't get to do that as a lawyer.
You can't do that. Yeah, exactly.
Yeah.
You mentioned earlier your affinity for Judge Bork, and I wanted to touch on another topic that he brought up during his confirmation process in the U.S. Supreme Court, which was the notion of one man, one vote. He argued that that was an improper extension of the federal government's oversight of a Republican form of government. That the U.S. Congress has a bicameral legislature, and it's one's made up of representing population, the other one represents states, and you have states that have their constitutions or did at that point in time prior to the Reynolds Sims decision, that you can have one senator per county if that was so your desire. Have you looked at that, or
I have not looked at it closely enough to be able to state an opinion on it, but it does occur to me that if Wyoming can have two senators and California can have two senators, that would be such an egregious violation of the one man, one vote principle that
fortunately
maybe the one man, one vote principle doesn't hold. And we have to remember that these are Warren Court and Berger Court decisions that we're still and so now we see the results. This is the great benefit of history and why Clarence Thomas's opinions are so important. You really want to look at how it's turned out. So how has it turned out for Idaho? Well, we could look at our neighboring states also. Everybody knows Seattle and Olympia run the whole state.
right.
Eastern Washington wants to be part of Idaho so bad, they say, because they're being ignored by their own state capital, same as in Portland. Now we're running into a situation where Boise is starting to run the state of Idaho, and all the rural interests are going, hey, what about us? And so, you can say one man, one vote, but you also somehow have to account for the fact that the rural people are just being ignored in preference to the urban policy just because there's more people in the urban area.
So is that the kind of thing? And I know Attorney General Wasden's office has been asked about that. Is that something that you would entertain reviewing and advising?
Sure. Yeah, I would have to. And the reason is because not because I'm a policymaker as opposed to a lawmaker, but as a law enforcer, it's prudent to look at what incentives are in the law and how it all works out when the law is constructed a certain way. And so if because of lived experiences we can see that representation is all flowing to Boise and the whole ag community is really being ignored. The whole rural, all of Idaho County, who needs it? Don't pay attention to those people. Chalice, nobody even knows where that is. Right?
You do all the legislative districts are basically in Ada and Canyon County. And
You see that this starts to happen. And I think that maybe the legislative districts for the House could be devised that way by population. I don't see a problem with that because that is the House where the will of the people is expressed. But as a proper limit on the size and growth of government, there has to be a doorstop in the Senate. There has to be a stop that says, all these people think that we should have to do this, but the Senate says no. Why does the Senate say no? Because all the people in all the counties don't want to have anything to do with that. And so here we have a situation where we really need to, again, pull back and say, we have this government designed to protect the rights and freedoms and liberties of the people. If the Senate is not a block to what the will of the people wants to just trammel over everybody and do whatever the will of the people, which ends up in, when are we bringing out the guillotines, right? We know how the French Revolution.
We don't like that you're not wearing a mask. Kill that guy.
We know how that comes out historically.
Yeah.
It's not a good idea. But the other side of the coin is that needs to be remembered is that we don't want the government to solve all our problems. If everyone in the state of Idaho woke up in the morning and had a problem and said to themselves, what is the private solution to this problem? If every single one did that and didn't go running to the government, let's call the governor's office. I am incensed. I'm calling my legislator.
Right.
You know what? Resolve it yourself. How about this? Resolve it in your own community with your own people for yourself. You want to talk about local control? Local control is also private control.
Individuals and families. I often describe the analogy, not that I've seen it happen, the husband and wife in their small unit of government, the family, have an argument about what color to paint the fence. So what do? They naturally go to the city council, which then passes an ordinance that says the house at 123 Pine Street is going to be blue. And no one would think to do that, but we bring all of our problems to the government, and now we have a large government.
Well, we have to understand, Wayne, that we've been trained to do this.
We have been trained to.
When I was a kid, my brother and I would fight. I grew up in a family of 5. I'm the child in the middle, so I'm the great mediator, right? We fought like cats and dogs. And my father would always say, and my dad was a Goldwater and 64 guy. He was as conservative as they get. And he would say, don't make a federal case out of it. Right. And what does that mean?
What does that mean?
That means don't go to the government to solve your problems.
Right.
And what he was kind of saying was, don't bother your mother and I with your stuff. Okay. You guys work it out amongst yourselves.
Which is what you'd expect. But now we have government deciding everything about it, everything.
And we have to reject this. We have to cognitively, we have to see it, that it's happening, and then we have to reject it.
So we talked a little about Lawrence Wasden and your objections to some of the things he's done, and folks who are really into politics or have watched the debates, they don't need us to go back over all those things. But talk to us just a little bit about the difference between you and Raul Labrador. And you alluded to it a few times, but not specifically. Why you and not Raul?
Long story short, in my view, as a lawyer, Raul is a mile wide and an inch deep. I don't think he has a good, strong understanding of the two constitutions and how they relate to each other. I don't think he has good training in the form of the republic and how it should be operational at its best, because when it's operating best, it actually protects the people. Um, and he doesn't have a good track record. In 2014, he couldn't even convene the state convention in Moscow. And my understanding is that the Ada County delegation did their credentialing process in a way that didn't meet with the the state GOP's requirements. And he didn't want to exclude his buddies in Ada County. So he didn't even convene the meeting. It never got off the ground. A strong leader would have said, "You guys didn't meet the credentialing process. You're out." And Ada County, oh, they would have hit the ceiling. But it would have been the proper thing to do if he'd have just followed the rules. Um, he goes to the state legislature. I don't know what kind of bills he got passed there. I don't think there was a lot of them. Certainly, he didn't. He said in the debate the other night, "Well, that was my idea when I was in the legislature, was to put some attorneys back in the legislative branch." But I haven't seen the bill where he actually offered to set up a legislative counsel's office. I don't think he would really know how to do it. Whether maybe he does, maybe he doesn't. He goes to Congress for 3 or 4 terms. So we know he's living off a federal pension. And now he's looking to become a law enforcer as opposed to a policymaker. And all of his name recognition is about his policy, his conservative policy making credentials. And he says, I know Mark Meadows and Jim Jordan and all these people, and we've worked out this and we've worked out that. It's all policy. It's very little in law. He hasn't made really any impression in the legal community for doing anything as a lawyer. And so, if anything, if you're 120 attorneys in the AG's office, you want to have a leader in there who has actually made their mark in the law and can provide direction and be a thought leader in how this whole office is going to operate. I don't think he can do that.
Is there something to be said for, I mean, you ran for the legislature, a lawyer running for the legislature. So, I mean, if you had one, you would be working on policies, even though you're a lawyer, and no one says, well, that guy's a lawyer. He shouldn't be here. We're working on policy. But isn't there some intermingling that maybe is okay? I don't know. I guess people can decide if that's okay enough, but you have made that a point. I think in an email you and I exchanged, you said something to the effect, "Do you want a lawyer or a policy guy?" And
Well, let's look at the differences. In 2016, I ran against Luke Malik, for the state legislature in District 4. Through the process of that race, I realized that I am not a policymaker, that I'm a better lawyer than I am a policymaker. And what is the difference? The difference is a policymaker looks at the law and says, the will of the people says that we need to take the law in this direction, not that direction, not this third direction, but this direction over here. And then you have to make your arguments for why the law needs to change. A lawyer, a law enforcer, all they do is they look at the law and they say, this is the law the way it is. And so this is the law that we're going to enforce. And it's not as if it's black and white, because as you can tell from our earlier conversation here, the federal government owns all this land in the state, and they probably shouldn't own all this land in the state. And so the AG is going to have to step out and say, look, you don't own all this land in the state, or it's not proper for you to do so because of X, Y, and Z. That's not making policy. That's actually saying that policy making was done against the law. And so we have to go back and stick to the law and get rid of that policy.
you don't think you're saying much the same thing, only in a different way? I mean, the end result seems to be very similar.
No, I think it's quite different. A lawyer, there's a particular analytical way to view the law when you're about to enforce it, as opposed to how you view the law when you're making new law. When you're making new law, you're primarily concerned with incentives and structure. That is to say, we know that when we change the law, we're going to put incentives in there for people to act or not act in certain ways. And given that, we have to look at the structure and say, is this the proper way to do it? Given that the entire purpose of government is to protect liberties and freedoms, do we really want to go out and start regulating every single occupation so everybody has to have a license to curl hair or, build coffins or something like that? That would be where you could say, well, okay, the incentives part of that might work. But given the structure of the law, we don't want to do that. We don't want to provide those incentives. And so those policy making, analytical and methodological functions are different than a law enforcer. So the law enforcer is just going to look at the law and say, is this the law that the legislature passed? And is it a constitutional law that I can enforce? Now, if the legislature passes an unconstitutional law, I might not know it's unconstitutional until it passes, but I would probably have that discussion with the governor. Say, look, before you sign this, I think this is unconstitutional. I think you're going to get us into a lawsuit. I think it's avoidable, and here's why.
So how does that differ from what Lawrence Wasden claims he does? I just call balls and strikes, he says.
Well, Lawrence Wasden's difference is that he doesn't account for the voters and he doesn't account for the Article I rights of the people when he advises, apparently. I mean, I don't know what he actually advises. And that's one of his main complaints. You have no idea what I said to the governor. Well, that's true. But if he did talk to the governor about the Article I rights of the people when the governor was contemplating closing churches and businesses, which I don't think he has the constitutional right to do, then he's not a very good lawyer, because a hallmark of a good lawyer is you keep your client within the bounds of the law. That's one thing that we do. We do it all the time. I mean, dozens and dozens, if not hundreds of clients have said to me, well, I'm just going to ditch up that road so he can't use it. I'm like, well, you probably don't want to do that, because here's the way that goes. Here's the road that you'll be on. People want to change circumstances right in the middle of a lawsuit, and you have to talk them out of it. You have to say, nope, this is already before the judge. You don't want to do that. And so good lawyers are good lawyers enough to keep their clients lawful. And Lawrence Wasden has not been able to do that.
And you don't think that I mean, I'm put words in your mouth, obviously. You think that Raul Labrador wouldn't do that or isn't capable of doing that?
Both. Partially because Raul needs friends. He's much too nice of a guy. When you sit down and talk to him, and he'll tell you, I want to partner with the legislature. It's right on his website for his campaign. I will partner with the legislature. Well, you're not supposed to partner with the legislature from the executive branch. That's not the way the government's designed to be handled. We can't all just go out and have a beer together and resolve it. It's not the way it works. You usually, as an attorney, have to put your foot down and say, no, you can't go any further than this. And here's why, and tell them. Because the job of the AG is to tell people what they need to hear, not what they want to hear. My concern about Raul is he would be more inclined, in my view, to tell people what they want to hear as opposed to what they need to hear. He's not, I don't think he's tough enough. I don't think he's got it in him to actually fight for the people of Idaho.
Okay. Any other comments, thoughts that we didn't touch on? We've been going for an hour and 18 minutes. I've enjoyed this conversation thoroughly, but I want to make sure we didn't leave anything out.
Well, I just think that, I'm very, very anxious to get into the office and start to put my plans into effect. I don't know if you've noticed this, Wayne, but there's this thing in Idaho where employees are treated like widgets. Like if this one doesn't work, you just throw them away and plug in a new one, and it's just fine. And treating people like that when they are professionals, when they're lawyers, just does not cut it. And so part of the thing that I really look forward to is providing a positive vision and a set of goals in the AG's office that the deputy attorney generals will go, you know what? That's a good direction to go in. I want to be involved in that. And when I heard during the debates, I think it was that there's been a 20% turnover rate this last year in the AG's office. That's like 40 people or something. That's a lot. And and it's a lot, not only because you're just disrupting processes across the board when anybody walks out the door, but you also have retraining now. It also does provide an opportunity for reprocessing and redoing those types of things. But I really think leadership requires someone who's going to set a positive vision. This is where we're going. This is why we're going there. Come on along. Let's do it. And so when A.G. Wasden says, well, those people just leave because of money, I think that paints attorneys as being too craven. In my experience, attorneys are just like anybody else. If you provide them with a great work environment, they'll work for less money. They'll be like, are you kidding me?
So you think that's it, that the work environment over there is bad?
It must be, or people wouldn't be leaving.
I mean, do you think it's just not a fun job, or just not a fun place to work, or not interesting, not challenging?
The law is actually quite fun. I mean, maybe people wouldn't see it that way, but being presented with a true legal problem and then trying to work through the analytics of figuring out what to do, and you get to these junctions and you have to make a judgment. Do I go left or right? It is really intellectually very stimulating and can be very exciting. And I think that those deputy attorney generals crave that. I mean, you come out of law school or you come out of a private firm, you're going to be working for the state of Idaho, and you're going to be doing it in what is frankly a noble profession. We get to tell the truth all the time as attorneys. That's really an honor. We don't have to cut corners with anybody. We can just say, no, that's actually not right. What's actually right is this. And here's why, A, B, C, D, E. It's really kind of fulfilling. And so I think the attorneys in the AG's office should not be leaving. What they should be looking forward to is a true leader who can make them, I don't know if you've ever had a job like this, but I've had several. You jump out of the bed in the morning, you're like, I got to get to work. Where's my lunch? Oh gosh, I got to make lunch. I'm going to eat out today. And then you blow right through lunch and suddenly you're there after 6 because you're loving it. You're loving your job.
Believe it or not, Art, that is my job. I have the best job anywhere of anybody, with a great team, and we have a wonderful time slaying the socialist dragons.
So, this is what I look forward to in the AG's office more than, the mechanics of where the attorneys are and on all that kind of stuff. I really look forward to working with a group of professionals that are energized and we're moving forward for the people of Idaho. And that's who we work for. We work for the people of Idaho. And so I'm really looking forward to it. I hope I get elected on May 17. I'm looking forward to the general in November. And what I'm really looking forward to, I guess it would be January 2nd when I walk into the office and get to actually start. I mean, I'm a private sector guy. I'm raring to go. So I don't know. I don't see the excitement in any of the other two candidates. They're just not that excited about it. They're like, well, this is administrative. And
well, I'm hoping we'll have a chance to find out. I've seen both of them on the campaign trail, of course, but we have made the invitation and to all the different statewide candidates, and that includes Lawrence and Raul, and hopefully they'll have a chance to come on here and express their opinions about these different things.
Well, I hope they do. And I don't want to take up any more of the night. Gosh, who's going to watch it this late?
This has been, I had a lot of fun. I love this stuff. I can keep going, but at some point I'm going to have to go to the bathroom or something.
Yeah. Well,
but anyway,
this document is for you. This is your own private copy.
Well, thank you. I will cherish it always.
Well, I've been handing them out all over the campaign trail.
People don't know how big the state constitution is, and they don't talk about it enough. There are actually some really good provisions in the state constitution, in the Declaration of Rights that I think are beyond even what the federal government.
Oh, when I tell them your Section 11 of Article 1 protects your gun rights more than the Second Amendment,
exactly.
People's jaws drop. They're like, what?
Yep. The right to petition your government is better in this document than it is
Yeah.
in religious free. Anyway, there's just so many different things, but people don't know enough about it and they don't read it. There's also a lot of crap in here too.
I tell them all
that
to
got
read
added,
it.
you
They
know.
have to read it.
Yeah, there's a lot of stuff that got added by special interest groups over the years. They just
I
gotta
think
read
that's true. And when I read it, I see that. But, you know, the only people that can change it are the people. You know, I read the Farm Bureau's policies the other
Yeah,
day,
yeah,
and there were 2 or 3 or 4 different opportunities for constitutional amendments. And sometimes they didn't phrase it as such, but I saw it and I was like, that's a good one. So anyway,
Thank you all for watching. Hey, come back again on Tuesday if you want another riveting conversation, this time with Brandon Durst, who's running for state school superintendent. So thanks again for watching, and we'll talk to you next time.